Rule 8 Continuation. Q. In his complaint for foreclosure of mortgage, to which was duly attached a copy of the mortgage deal, Plaintiff PP alleged inter alia as follows. Number 1. That defendant DD duly executed the mortgage deed, copy of which is annexed A of the complaint, and made an integral part thereof. And 2. That to prosecute his complaint, plaintiff contracted a lawyer, CC, for a fee of 50,000. In his answer, defendant alleged inter alia that he had no knowledge of the mortgage deal, and he also denied any liability for plaintiff's contracting with the lawyer for a fee. Does defendant's answer as to plaintiff allegation number 1 as well as number 2 sufficiently raise an issue of fact? Reason. Defendant's answer to plaintiff's allegation number 1 does not sufficiently raise an issue of fact. The third mode of specific denial may not be availed of when the fact as to which want of knowledge or information is claimed is so plainly and necessarily within the defendant's knowledge that his averment of ignorance must be palpably untrue. The defendant must aver positively whether he duly executed the mortgage deal or not. Not deal, but deed. It cannot be that he had no knowledge of plaintiff's allegation. Capital Motors versus Yabut. Defendant's answer to plaintiff's allegation number 2 also does not sufficiently raise an issue of fact. In a case involving similar facts, the Supreme Court held that where defendant did not deny the alleged fact regarding the engagement of a lawyer for a fee but denied only his liability therefore, he is deemed to have admitted the alleged fact. Galofa versus Nibon Singh. Q. Lim filed an action for forcible entry against Gaza and other defendants. Paragraph 2 of the answer states that defendants specifically deny the allegations in paragraph 2 and 3 for want of knowledge or information sufficient to form a belief as to the truth thereof, the truth of the matter being those alleged in the special and affirmative defenses of the defendants. In the special and affirmative defenses, the defendants allege that plaintiff did not show concrete title while the defendants are owners by virtue of the TCT, which was annexed to the answer. Did the defendant specifically deny the allegation in the complaint regarding Lim's prior physical possession and the defendant's unlawful physical invasion? The answer is yes. While the substance of the matters upon which defendants relied upon to support their denial was not stated in paragraph 2 of the answer, these were stated or indicated in the special and affirmative defenses, Gaza versus Lim, GR 126863. Affirmative defenses. How shall a defendant raise his affirmative defenses? A defendant shall raise his affirmative defenses in his answer, which shall be limited to the following. A. The affirmative defenses stated in the second paragraph of Section 5, letter B, Rule 6, that is, number 1, lack of subject matter jurisdiction, 2, lis pendens, 3, res judicata, as well as the following: lack of personal jurisdiction, improper venue, lack of legal capacity to sue, failure to state a cause of action, failure to comply with the condition precedent for filing the claim. The affirmative defenses under the first paragraph of Section 5, letter B, Rule 6, which include fraud, prescription, release, payment, illegality, statute of fraud, estoppel, formal recovery, discharge in bankruptcy, and other matters by way of confession and avoidance. Section 12, Rule 8, 2020, Rules of Civil Procedure. How should the court resolve or act on the affirmative defenses? The affirmative defenses under letter A above shall be motu proprio resolved by the court within 30 days from the filing of the answer. Section 12, letter C, Rule 8, 2020, Rules of Civil Procedure. As to the affirmative defenses under letter B, the court may conduct a summary hearing within 15 days from the filing of the answer. Such affirmative defenses shall be resolved by the court within 30 days from the termination of the summary hearing. Section 12, letter D, Rule 8, 2020, Rules of Civil Procedure. Under the first paragraph, the court has a duty to resolve the affirmative defenses, while in the second paragraph, the court has the discretion to conduct or not the summary hearing for the resolution of the affirmative defense. If the court decides not to conduct the summary hearing, the affirmative defenses would be resolved during the trial proper. Subject to the right of appeal, an order granting a motion to dismiss or an affirmative defense that the cause of action is barred by a prior judgment or by statute of limitations, that the claim or demand set forth in the plaintiff's pleading has been paid, waived, abandoned, or otherwise extinguished, or that the claim on which the action is founded is unenforceable under the provisions of the statute of frauds, shall bar the refiling of the same action or claim. Section 13, Rule 15, 2020 Rules of Civil Procedure. When should the affirmative defenses be raised? Affirmative defenses should be raised at the earliest opportunity. Otherwise, the failure to do so shall constitute a waiver thereof. Section 12, letter B, Rule 8. What is the remedy of the defendant from the denial of the affirmative defense? Affirmative defenses, if denied, shall not be the subject of a motion for reconsideration or petition for certiorari, prohibition, or mandamus, but may be among the matters to be raised on appeal after a judgment on the merits. Section 12, letter E, Rule 8. Lack of legal capacity to sue. What is meant by the plaintiff having no legal capacity to sue? The term lack of legal capacity to sue means either that the plaintiff does not have the necessary qualifications to appear in the case because he is not in the full exercise of the civil rights, or of his civil rights, as in the case of a minor, or incompetent who is not assisted by his father, mother, guardian, or guardian ad litem, or when he does not have the character or representation which he claims, as when he is not a duly appointed executor or administrator of the estate he purports to represent. Thus, an administrator has no legal capacity to sue after her resignation, as such has been accepted by the court. Lau versus D. L 3890, 1952. Other examples are a foreign corporation doing business in the Philippines without a license, Section 133 of the Corporation Code, and 2, an unincorporated association. In 1992, Petitioner Obando, in his capacity as co-administrator of the estate of the spouses Figueras, filed a complaint against Eduardo and Amigo Realty Group, who are the respondents, for the nullification of sale of a real property. The respondents filed their answer. However, the probate court in the state proceedings issued an order dated 17 December 1997, removing petitioner from his office as co-administrator of the estate of the Figueras spouses after his conviction of estafa through falsification of public document. Consequently, in the civil case, respondents filed a motion to dismiss dated 27 January 1998 after petitioner had rested his case. The respondent's ground for dismissal was the lack of legal capacity to sue of petitioner after having been removed as co-administrator. The petitioner argued that the motion to dismiss should be denied since the rules provide that a motion to dismiss may be submitted only before the filing of a responsive pleading. Petitioner argued that it was already too late for respondents to file a motion to dismiss after petitioner had finished presenting his evidence. May the trial court grant the motion to dismiss? The answer is yes. It must be pointed out that it was only after petitioner had been convicted of estafa through falsification that the probate court divested him of his representation of the Figueras estate. It was only then that the ground of lack of legal capacity became available to the respondents. Hence, could not be said that they waived it by raising it in a motion to dismiss filed after their answer was submitted. If the plaintiff loses his capacity to sue during the pendency of the case, the defendant should be allowed to file a motion to dismiss even after the lapse of the reglementary period for filing a responsive pleading. Obando v. Figueras, 322-148, 2000. When the plaintiff is not the real party in interest, what is the ground for dismissal? Failure to state a cause of action. That is in Casimiro v. Roque, 98 Phil 880. Distinguish between lack of legal capacity to sue and lack of personality to sue. A litigant lacks the personality to sue when he or she is not the real party in interest. In this situation, The initiatory pleading may be dismissed on the ground of failure to state a cause of action. The lack of a legal capacity to sue, on the other hand, refers to a litigant's general disability to sue, such as on account of minority, insanity, incompetence, lack of juridical personality, or any other general disqualifications of a party. In this case, the initiatory pleading may be dismissed on the ground of lack of legal capacity to sue. When an entity has no separate juridical personality, it has no legal capacity to sue. That is, Section 1, Rule 3 states that only natural or juridical persons or entities authorized by law may be parties in a civil action. National Electrification Administration versus Maguindanao Electrical or Electric Cooperative, April 11, 2018. Plaintiff Zuiden Brothers Limited is a Hong Kong corporation. On several occasions, GTVL Incorporated purchased lace products from Zuiden. As per instruction of GTVL, the lace products were delivered by Sweden to Cancer Limited, a Hong Kong corporation. The products are then considered as sold upon receipt of Cancer of the goods purchased by GTVL. Cancer then had the obligation to deliver the products to the Philippines and or to follow whatever instructions GTVL had on the matter. GTVL failed to pay Sweden, so the latter brought a suit before the RTC of Paranaque City for collection of sum of money. GTVL filed an answer raising the affirmative defense of plaintiff's lack of legal capacity to sue. It was alleged that Sweden is doing business in the Philippines without a license and thus barred from suing under Section 133 of the Corporation Code. Should the action be dismissed, the answer is no. An unlicensed foreign corporation not doing business in the Philippines can sue before Philippine courts. The transaction between Sweden and GTVL cannot be considered as doing business in the Philippines. An essential condition to be considered as doing business in the Philippines is the actual performance of specific commercial acts within the territory of the Philippines for the plain reason that the Philippines has no jurisdiction over commercial acts performed in foreign territories. Here, the perfection and the consummation of these transactions were done outside the Philippines. Moreover, the transactions are simply export transactions. An exporter is not deemed to be doing business in a foreign country by the simple fact of exporting products to such foreign country. Van Sweden Brothers Limited versus GTVL Merchandise Industries, GR number 147905, May 28, 2007. Q. May a corporation file a case after its dissolution in the lapse of the 3-year grace period provided for it in Section 122 of the Corporation Code? The answer now is no. In such a case, the corporation petitioner lacks capacity to sue because it no longer possesses juridical personality by reason of its dissolution in lapse of the 3-year grace period provided for under Section 122 of the Corporation Code. The case was properly dismissed on ground of lack of legal capacity to sue. Alabang Development Corporation versus Alabang Hills Village Association, June 2, 2014. Pleading asserting the claim states no cause of action. When does a pleading fail to state a cause of action? A pleading fails to state a cause of action when it contains no allegation that there is an act or omission by the defendant which violated the right of the plaintiff. For example, a complaint to collect on a promissory note which avers that the promissory note is not yet due, but that the defendant was having financial difficulties. Mere financial difficulty does not make the obligor lose the benefit of the period under Article 1198 of the Civil Code. Where the plaintiff's cause of action is premature, is there a ground for a motion to dismiss? Yes. A complaint which contains a premature cause of action may be dismissed for failure to state a cause of action. Erlanger and Gallinger, Incorporated, versus Villamore, L8767. Distinguish failure to state a cause of action from lack of cause of action. Failure to state a cause of action relates to the failure of the allegations of the pleading to state a cause of action, while lack of cause of action relates to a failure of proof, that is, the plaintiff's failure to prove by evidence his allegations relating to his cause of action. Dismissal of the complaint on the ground of failure to state a cause of action would not bar the refiling of the complaint, while a judgment for defendant on the ground of lack of cause of action would amount to res judicata. Failure to comply with the condition precedent. May a court motu proprio dismiss a case for failure to comply with Article 151 of the Family Code? No. Noncompliance with the earnest effort requirement under Article 151 of the Family Code is not a jurisdictional defect which would authorize the courts to dismiss suits filed before them motu proprio. Rather, it merely partakes of a condition precedent such that the noncompliance therewith constitute a ground for dismissal of a suit should the same be invoked by the opposing party at the earliest opportunity, as in a motion to dismiss or in the answer. Otherwise, such ground is deemed waived. Moreno versus Cont, 30 July 2018. That ends the examples for Rule 8. Rule 9. Effect of failure to plead. What is the effect if defenses and objections are not pleaded either in a motion to dismiss or in the answer? They are deemed waived. However, when it appears from the pleadings or the evidence on record that the court has no jurisdiction over the subject matter, that there is another action pending between the same parties for the same cause, or that the action is barred by prior judgment or by statute of limitations, the court shall dismiss the claim. Petitioners Rebecca and Rosalie, children of spouses Lourdes and Luciano Pacana, filed an action for accounting and damages against Rovilia Incorporated and respondents. The petitioners alleged that respondents had embezzled the funds and property of Rovilia Water Supply, the family business owned by their parents. The petitioners filed the complaint in their own names, although Rosalie was authorized by Lourdes through an SBA. Lourdes and Luciano died. The petitioners informed the court of these developments and amended the complaint, but the caption of the amended complaint remained the same. Respondents filed a motion to dismiss on the ground of lack of jurisdiction, which was denied and later an answer. During the pre-trial, the respondents stated for the first time that they would seek the dismissal of the complaint because the petitioners are not the real parties in interest, but rather the deceased spouses, Pacana, who are the alleged owners. The RTC issued a pretrial order where one of the issues submitted was whether the complaint should be dismissed for failure to comply with Section 2, Rule 2, which requires that every action must be prosecuted in the name of the real parties in interest. Respondents then filed a motion to dismiss on the ground that the petitioners are not the real party in interest, and hence the complaint fails to state a cause of action. Petitioners argued that the ground of failure to state a cause of action was waived, while respondents countered that the ground of failure to state a cause of action was timely raised pursuant to Section 2, letter F of Rule 18. Should the motion to dismiss be granted? The motion to dismiss should not be granted. Under Section 1, Rule 9, defenses and objections not raised either in the motion to dismiss or in the answer are deemed waived. Under the 1997 rules, grounds other than lack of subject matter jurisdiction, res judicata, lis pendens, and prescription are deemed waived if not raised either in the motion to dismiss or in the answer. Failure to state a cause of action was deleted as an exception to the waiver rules. Again, failure to state a cause of action was deleted as an exception to the waiver rule. Although Section 2, letter F, Rule 18 provides that the court, during the pre-trial, may consider the propriety of dismissing the action should a valid ground thereof be found to exist, this applies only to the issues that would govern the trial proper. The issue of failure to state a cause of action can no longer be taken up by the trial court since it had been waived under Section 1, Rule 9. Pacania Contreras versus Rovilia Water Supply, GR 168979. What is the effect if the compulsory counterclaim or cross-claim is not set up in a case? It shall be barred under Section 2 of Rule 9. What is the reason behind Section 2, Rule 9? The rule is designed to achieve resolution of the whole controversy at one time in one action and to avoid multiplicity of suits. Backline versus Court of Appeals. 182 SCRA 761. How should a compulsory counterclaim or cross-claim be set up? A counter or compulsory counterclaim or a cross-claim that a defending party has at the time he files his answer shall be contained therein. Section 8, Rule 11. May a compulsory counterclaim be set up in a motion to dismiss? No. The Supreme Court has stated that if the defendant has a compulsory counterclaim, he should not file a motion to dismiss but an answer with a counterclaim, with the ground for the motion to dismiss being asserted as an affirmative defense pursuant to Section 6, Rule 16. In such a case, a dismissal of the complaint shall be without prejudice to the prosecution in the same or separate action of a counterclaim pleaded in the answer. Financial Building Corporation versus Forbes Park, GR 133119. What is the remedy of a party if he fails to set up his counterclaim or cross-claim in the answer? When a pleader fails to set up a counterclaim or a cross-claim through oversight, inadvertence, or excusable neglect, or when justice requires, keyword is JOIE, he may, by leave of court, set up the counterclaim or cross-claim by amendment before judgment. Section 10, Rule 11. What is the rule on pleading regarding after-acquired counterclaims or cross-claims? An after-acquired counterclaim is merely permissive even if it arises from or is connected with the transaction or occurrence constituting the subject matter of the opposing party's claim. A counterclaim or a cross-claim which either matured or was acquired by a party after serving his pleading may, with the permission of the court, be presented as a counterclaim or a cross-claim by supplemental pleading before judgment. In Banco de Oro Universal Bank versus Court of Appeals, GR 160354, 25 of August 2005, the Supreme Court also allowed the setting up of the after-acquired counterclaim in a separate action. If a compulsory counterclaim or cross-claim not set up is made the subject of a separate action, what is the remedy of the defendant? The remedy of the defendant is to file a motion to dismiss or answer raising the ground of litis pendentia if the first case is still pending, or the ground of res judicata if the first case is already final and unappealable. The basis for this is that under Section 47, letter B of Rule 39, the final judgment is conclusive not only with respect to the matter directly adjudged, but also as to any other matter that could have been raised in relation thereto. Metals Engineering Resources Corporation versus Court of Appeals, GR 95631. P sues D for tort. D files a motion to dismiss on the ground that res judicata. The court dismisses P's complaint, and the dismissal order becomes final and unappealable. Later, D sues P for moral and exemplary damages for having brought a harassment suit. P moves to dismiss on the ground that the claim for moral and exemplary damages should have been brought as a counterclaim in the tort case. Should a motion to dismiss be granted? Yes. Had D wanted to prosecute his claim for moral and exemplary damages, he should have not filed a motion to dismiss but an answer wherein he should have raised res judicata as an affirmative defense and included a counterclaim in the answer for moral and exemplary damages. Not having done so, the claim for damages is barred under Section 2, Rule 9. Declaration of default. When may a defendant be declared in default? What happens thereafter? If the defendant fails to answer within the time allowed therefor, the court shall, upon motion of the claiming party, with notice of the defending party and proof of such failure, declare the defending party in default. Thereupon, the court shall, number 1, proceed to render judgment granting the claimant such relief as his pleading may warrant, or, in its discretion, require the claimant to submit evidence. Rule 9, Section 3. May the reception of evidence be delegated? Yes, it may be delegated to the clerk of court, who must be a member of the bar. Section 3, Rule 9. Should a motion to declare a defendant in default be set for hearing? While such a motion is a litigious motion, a hearing is discretionary upon the court. Section 6, Rule 15. The defendant, however, should be given the chance to oppose the motion to declare him in default. May the court motu proprio declare a defendant in default for failure to timely file an answer? No. There should be a motion by the plaintiff. Note, however, that under the rules on summary procedure, the court may motu proprio render judgment in favor of the plaintiff if the defendant fails to timely answer. Q. What is the effect of the order of default? A party in default shall be entitled to notice of subsequent proceedings but not to take part in the trial. Section 3, letter A of Rule 9. Q. Plaintiff filed an action for sum of money against the defendant before the MTC. For failure to answer, the defendant was declared in default. Subsequently, however, the MTC dismissed the case motu proprio for failure of the plaintiff to comply with the requirement of prior barangay conciliation. Was the motu proprio dismissal proper? No. The ground of noncompliance with the condition precedent, that is, undergoing proper or prior barangay conciliation proceeding, was not invoked at the earliest opportunity, as in fact, respondent was declared in default for failure to file responsive pleading despite due notice. Hence, such ground was deemed waived. Lansangan versus Kaisip, August 6, 2018. May a party who is declared in default testify in behalf of the non-defaulted defendant? The answer is yes. There is nothing in the rules of court which prohibit or disqualify a defaulted party from being a witness for the non-defaulted defendant. Cavili versus Florendo, GR 73039, October 9, 1987. Q. D, E, and F are solidarily indebted to P in the amount of 900 pesos, rather 1,000 pesos. P filed a complaint for collection of the 900,000 pesos against D, E, and F before the RTC. P filed an answer within the reglementary period, but E and F did not. Questions. A. May E and F be declared in default upon motion of P? May P move for a default judgment against E and F? May E and F take part in the trial? May E and F testify in behalf of D? Answer to letter A. May E and F be declared in default upon motion of B? Yes, since E and F did not file their answers. Letter B. May P move for a default judgment against E and F? No. This is a case of partial default under Section 3, letter C of Rule 9. When a pleading asserting a claim states a common cause of action against several defending parties, some of who answer and the others fail to do so, the court shall try the case against all upon the answers thus filed and render judgment upon the evidence presented. Here, the court should try the case against D, E, and F upon the answer filed by D. May E and F take part in the trial? The answer is no. A party in default shall be entitled to notice of subsequent proceedings but not to take part in trial. May E and F testify in behalf of D? The answer is yes. A defaulted party is not disqualified from testifying in court in behalf of a non-defaulted party. Q. P filed a complaint against D, E, and F, wherein he alleges that defendants are jointly indebted to him for 900,000. D filed an answer within the reglementary period, but E and F did not. May E and F be declared in default upon motion of P? The answer is yes, since E and F did not file the answer within the reglementary period. May P move a default judgment against E and F? Yes, the provisions of Section 3, letter C, Rule 9 do not apply since the complaint does not state a common cause of actions against D, E, and F. In a joint obligation, each obligation of the joint debtor is separate and distinct from the other joint debtors. Here, the court may render default judgment against E and F, ordering them to pay 300,000 each to P. P filed a complaint for collection of a 500,000 loan against D. D did not file an answer and was declared in default. The clerk of court received P's evidence which proved that the amount of the loan was actually 550,000 pesos. May the court award 550,000 to P? The answer is no. A judgment rendered against a party in default shall not exceed the amount or be different in kind from that prayed for, nor award unliquidated damages. Section 3, letter D, Rule 9. This is different from the rule where the defendant was not declared in default and which is thus covered by Section 5 of Rule 10. Q. Plaintiff sued defendant for collection of a 45,000 loan plus interest of 12% per annum from March 2, 1991 until full payment. Defendant did not file an answer and was accordingly declared in default. After plaintiff presented his evidence ex parte, the RTC rendered judgment ordering defendant to pay plaintiff $45,000 plus interest of 5% per annum from March to 1991 until full payment. Defendant failed to appeal. Subsequently, defendant filed a petition for annulment of judgment regarding the portion thereof that awarded 5% per month interest rather than 12 per annum interest. The plaintiff contends that the judgment has already become final and executory and that there are only two grounds for a petition for annulment, that is, extrinsic fraud and lack of jurisdiction, none of which is present. May the petition for annulment of judgment prosper? Yes. A petition for annulment of judgment is an exception to the final judgment rule, which states that final and executory judgment can no longer be set aside. While under Section 2, Rule 47, a petition for annulment of judgment may be based only on the grounds of extrinsic fraud and lack of jurisdiction. Jurisprudence recognizes lack of due process as additional ground to annul a judgment. A final and executory judgment may still be set aside if, upon mere inspection thereof, its patent nullity can be shown for having been issued without jurisdiction or for lack of due process of law. Here, the grant of 5% monthly interest is way beyond the 12% per annum interest sought in the complaint and smacks of violation of due process. The reason is that under Section 3, letter D, Rule 9, a judgment rendered against a party in default shall not exceed the amount or be different in kind from that paid for. Giona versus Belange, January 7, 2013. Whether the costs or cases wherein no defaults are allowed. In actions for annulment of declaration of nullity of marriage or for legal separation, if the defending party fails to answer, the court shall order the Solicitor General or his deputized public prosecutor to investigate whether or not a collusion between the parties exists, and if there is no collusion, to intervene for the state in order to see to it that the evidence submitted is not fabricated or suppressed. Section 3, letter E of Rule 9. Articles 48 and 60 under the Family Code. No judgment shall be based on a stipulation of facts or confession of judgment. Articles 48 and 60, Family Code. Attorney Victor Dabo is the lawyer of the defendant in civil case number 1286 of the Regional Trial Court of Manila, entitled Sweet Sugar versus National Landair. The defendant was served summons on 6 of July 2008. As of 17 October 2008, Attorney Dabo had not filed any responsive pleading on behalf of the defendant on account of numerous social engagements with important and prospective clients. On October 18, 2008, the counsel for the plaintiff filed with the court a motion to declare defendant in default, a copy of which was duly served upon Attorney Dabo. By way of opposition to the said motion, Attorney Dabo served and filed with the court a motion to admit answer, with the defendant's answer attached thereto. The tendered answer recited facts which constituted valid defenses to the claim asserted in the complaint. The counsel for the plaintiff opposed the admission of the answer, arguing that it was filed out of time, that the inattention of Attorney Dabo did not constitute fraud, accident, mistake, or excusable neglect, and that it would be unfair and unjust if the prejudice caused by the social activities of Attorney Dabo be inflicted upon the plaintiff and not upon Attorney Dabo and his client. What action should the court take? Reasons. Letter A. The court should admit the amended complaint. The Supreme Court has held that the defendant's answer should be admitted where it was filed before he had been declared in default, as default judgments are generally disfavored. Cathay Pacific Airways versus Romilo, 141 SCRA 451. De Los Santos versus Carpio, 501 SCRA 390. While Attorney Dabo unduly delayed in filing the answer, this was counterbalanced by the delay of plaintiff's counsel in filing the motion to declare the defendant in default. Moreover, the answer contained valid defenses. Cases should as much as possible be decided on the merits rather than on technicalities. What are the remedies of a party who fails to file an answer and or is declared in default? Before notice of order of default, file a motion to admit answer, giving a justifiable cause for the delay in the filing of the answer. Where an answer has been filed belatedly but before the defendant is declared in default, the court should admit the answer in order to resolve the case on the merits rather than on technicalities. Number two, offer order of default but before judgment. File a motion under oath to set aside the default order upon proper showing that his failure to answer was due to fraud, accident, mistake, or excusable negligence and that he has a meritorious defense. Number three, after judgment but before it becomes final, file a motion for new trial on the ground of fame under Rule 37. If the motion for new trial is denied, the defendant may appeal within 15 days from receipt of the order denying the motion for a new trial. Fame is fraud, accident, mistake, or excusable negligence. Number four, after judgment becomes final, file a petition for relief under Rule 38. If the defendant was improvidently or wrongly declared in default, he may move to set aside the judgment by way of a special civil action for certiorari. Number five, after a period to file a petition for relief has lapsed, file a petition for annulment of judgment based on extrinsic fraud under Rule 47. Q. P files a collection case for $500,000 against D. D was declared in default on the ground that his answer was filed beyond the reglementary period. D filed a motion for reconsideration in which he submitted proof that his answer was filed on the 15th day from service of summons. The trial court denied the motion on the ground that it was not accompanied by an affidavit of merits. Default judgment rendered against D, who will receive a copy of the judgment on March 1. D filed a motion for reconsideration, which was denied in an order received by D on April 1. On May 3, D filed a special civil action for certiorari with the CA to set aside the default judgment. P argued that the petition should be dismissed since the proper remedy was appeal. Should the petition for certiorari be dismissed? The answer is no. The trial court acted with grave abuse of discretion when it declared the defendant in default despite the fact that there was proof that he had timely filed his answer. Furthermore, a motion for reconsideration need not be accompanied by an affidavit of merits. Appeal is not an adequate remedy since D was not able to present any countervailing evidence before the court. ACO, Balancad versus Court of Appeals, GR 83888. Q. Tan filed with the MTC a collection case against Otero for failure to pay purchases of petroleum products. Otero failed to file his answer and was duly declared in default. During presentation of evidence ex parte, Tan presented the testimonies of his two Petron outlet employees who attended to Otero when he made his purchases. Tan also presented statements of accounts prepared by his employee Lito, who, however, was not presented to testify. The MTC rendered a default judgment in favor of Tan. On appeal, Otero contends that the MTC should not have taken into consideration the SOAs since Tan failed to authenticate them. The employee who actually prepared them not having been presented to testify. Nonetheless, the RTC and the CA affirmed. May Otero on appeal still raise the failure of Tan to authenticate the SOA? Yes. A defendant against whom a default judgment was rendered is not barred on appeal from challenging the judgment for being contrary to the law and the evidence. Hence, the defendant on appeal may challenge the evidence received as unauthenticated and as hearsay. Otero versus Tan, August 15, 2012. The SOA or statement of account were not authenticated as no witnesses or witness was presented to identify the signature of the one who prepared it. They were also hearsay since the one who prepared them was not presented in court nor was there a showing that he was unavailable to testify. May a party declared in default appeal from the default judgment of the RTC and file appeal brief in the CA? Yes. The provision that the defaulting party cannot take part in the trial only meant that he has already lost his standing in the trial court. In other words, the effect of the judgment of default is limited only to those stages in the prosecution of the case which terminated with and included in the judgment of the trial court on the merits. A defaulted party may appeal from the judgment rendered against him, and concomitant with the said right is the filing of the appellant's brief in order to be heard, or an appellant's brief if the one who appealed the judgment was the plaintiff. Royal Plainsview versus Mejia, November 12, 2018. Q. Distinguish between the effects of the failure to file an answer in a civil case governed by the summary rules and in civil case governed by the regular provisions of the rules of court. Letter A. Failure to file an answer. This is governed by Section 6 of the Rules on Summary Procedure. Regulamentary period to answer is 10 days from service of summons. Plaintiff files motion to render judgment. Motion to declare default or declare defendant in default is a prohibited motion. The court may motu proprio render judgment in favor of the plaintiff as may be warranted by the facts alleged in the complaint. The court cannot require plaintiff to submit evidence but should just render judgment as may be warranted by facts alleged in the complaint. Failure to file an answer under the regular provisions of the rules of court, and this is governed by Section 3, Rule 9. The regulamentary period, as a rule, is 15 days from service of summons. Plaintiff files motion to declare defendant in default. The court cannot motu proprio declare defendant in default, much less render judgment in plaintiff's favor. The court may proceed to render judgment granting the plaintiff such relief as his pleading may warrant or, in its discretion, require the plaintiff to submit evidence. And that is the end of Rule 9. Rule 10, amended and supplemental pleadings. How may a pleading be amended? Pleadings may be amended by 1. Adding or striking out an allegation or the name of any party, or 2. Correcting a mistake in the name of a party or a mistaken or inadequate allegation or description in any other respect. Section 1, Rule 10. What is the reason for allowing the amendment of pleading so that the actual merits of the controversy may speedily be determined without regard to technicalities and in the most expeditious and inexpensive manner? What are the kinds of amendments? Amendments may either be formal or substantial. A formal amendment is one which seeks to correct a mere defect in the designation of the parties and other clearly clerical or typographical error. Amendments which go beyond such corrections are substantial. Formal amendments may be corrected by the court at any stage of the action and its initiative or on motion, provided no prejudice is caused thereby to the adverse party, except where the amendment is a matter of right. A substantial amendment may be made only upon leave of court. Such leave shall be refused if it appears to the court that the motion was made with intent to delay or confer jurisdiction on the court, or the pleading stated no cause of action from the beginning which could be amended. Section 3, Rule 10, as amended by the 2020 Rules of Civil Procedure. When are amendments a matter of right? A party may amend its pleading once as a matter of right at any time before a responsive pleading is served, or, in the case of a reply, at any time within 10 days after it is served. Section 2. When amendment is a matter of right, should a pleader file a motion to admit the amended pleading? No, since it is the ministerial duty of the court to accept the amended pleading. The pleader should just file the amended pleading without any corresponding motion. Marcos Araneda v. Court of Appeals, GR 154096. What is the remedy of a party if an amendment is refused by the court, although the same is a matter of right? The party may avail of mandamus, since it is a ministerial duty of the court to accept the amendment made as a matter of right. The same case. When may the complaint be amended as a matter of right? At any time before the answer is served upon the plaintiff. Section 2. When may the answer be amended as a matter of right? Under the 1997 rules, an answer may be amended as a matter of right at any time before the reply, which is the responsive pleading to an answer, is served upon the defendant. However, under the 2020 rules, an answer may be responded to by a reply only if the defendant attaches an actionable document to the answer. It is submitted that if no reply is filed by the plaintiff, the defendant may amend his answer as a matter of right until the issuance of the pretrial order. Thereafter, the answer may no longer be amended if such amendment would raise an issue not included in the pretrial order. When may the reply be amended as a matter of right? Within 10 days after it is served. Example, P or F sues his brother G to recover ownership of a parcel of land, but the latter, within the period for pleading, moves to dismiss based on two grounds to it. First, the suit being between members of the same family. The complaint fails to aver that earnest efforts towards a compromise have been made, and second, the action is barred by extrinsic prescription. Pending resolution of the motion to dismiss, F serves notice to take G's deposition, which the latter opposes, claiming that at this stage of the proceeding, no deposition can be obtained without leave of court. Meanwhile, obviously, to meet G's objections in the motion to dismiss still unresolved, F files an amended complaint seeking this time the partition of the land between him and his brother and alleging that earnest efforts at amicable settlement have been exerted and have failed. If you were the trial judge, would you admit F's amended complaint and deny G's motion to dismiss despite the latter's contention that the amendment would result in a radical change of the cause of action or theory of the case? The answer is yes. If I were the trial judge, I would admit F's amended complaint. Under Section 2, Rule 10, a party may amend his pleadings 1 as a matter of right before a responsive pleading is served. Here, no responsive pleading has been served since a motion to dismiss is not a responsive pleading. Hence, F may amend his complaint as a matter of right. P filed a case for collection of $390,000 against D before the RTC of Las Piñas City. D filed an answer in which he raised lack of jurisdiction as an affirmative defense. P moved for leave of court to admit amended complaint in which P now seeks to collect $410,000. May the RTC admit the amended complaint? No. It is axiomatic that if the purpose of the amendment is to confer jurisdiction upon the court, then the court cannot admit the amendment complaint or the amended complaint. This is because the court, which does not have jurisdiction under an original complaint, is without power to admit an amended complaint. Rosario versus Carandang. P filed a case for collection of $390,000 against D before the RTC of Las Piñas City. D filed a motion to dismiss on the ground of lack of jurisdiction. P filed an amended complaint seeking to collect $410,000. Should the motion to dismiss be granted? Still, the answer is no. In this case, P may amend his complaint as a matter of right since a motion to dismiss is not a responsive pleading. Since the filing of the amended complaint is a matter of right, there is no power or discretion that needs to be exercised by the trial court. Hence, the amended complaint supersedes the original complaint and the trial court would have jurisdiction by virtue of the amended complaint. Rosario versus Carandang. On May 12, 2005, the plaintiff filed a complaint in the Regional Trial Court of Quezon City for the collection of $250,000. The defendant filed a motion to dismiss the complaint on the ground that the court had no jurisdiction over the action since the claim amount is $250,000 only, and it is within the exclusive jurisdiction of the Metropolitan Trial Court of Quezon City. Before the court could resolve the motion, the plaintiff, without leave of court, amended his complaint to allege a new cause of action, consisting in the inclusion of an additional amount of $200,000, thereby increasing his total claim of $450,000. The plaintiff thereafter filed his opposition to the motion to dismiss, claiming that the regional trial court has jurisdiction over his action, rule on the motion of the defendant with reason, asked in the bar. The motion to dismiss of the defendant on the ground of lack of jurisdiction should be denied. Under the rules of civil procedure, a plaintiff may amend his complaint as a matter of right before service of a responsive pleading upon him. The rules of civil procedure also provides that the amended pleading supersedes the original pleading. Here, the amendment was a matter of right since a motion to dismiss is not a responsive pleading. Hence, the amended complaint supersedes the original complaint and thus the RTC has jurisdiction. Q. Arturo lent $1 million to his friend Robert on the condition that Robert execute a promissory note for the loan and a real estate mortgage over his property located in Tagaytay City. Robert complied in his promissory note dated September 20, 2006. Robert undertook to pay the loan within a year from its date at 12% per annum interest. In June 2007, Arturo requested Robert to pay ahead of time, but the latter refused and insisted on the agreement. Arturo issued a demand letter, and when Robert did not comply, Arturo filed an action to foreclose the mortgage. Robert filed an answer in which he raised the affirmative defense of failure to state a cause of action as the debt was not yet due. On October 1, 2007, Arturo filed a motion to leave to admit amended complaint, alleging that Robert's debt had in the meantime become due, but that Robert still refused to pay. Should the amended complaint be allowed based on bar question asked in 2011? No. Section 3, Rule 10 was amended by the 2020 Rules of Civil Procedure, provides that leave to amend a pleading shall be refused if the pleading stated no cause of action from the beginning which could be amended. An amendment is not proper where the purpose is to cure a complaint which fails to state a cause of action because of prematurely and where there was a timely objection by the defendant. Swagman Hotels versus Court of Appeals. An amendment is not proper and should be denied if the plaintiff had no cause of action at the filing of the original complaint, and the purpose of the amendment is to introduce a subsequently accrued cause of action. The cause of action must exist at the time the action was begun, and the plaintiff will not be allowed by an amendment or supplemental pleading to introduce a cause of action which had no existence when the action was commenced or has commenced. Surigao Mine Exploration Company versus Harris. The Iglesia Ni Cristo filed a complaint against C.S. Soko and Carissa Holmes for specific performance and damages, wherein the INC prayed that a deed of sale over the subject parcel of land be executed in its favor. Carissa filed an answer, while C.S. Soko filed a motion to dismiss. Pending the resolution of the motion to dismiss, Carissa Holmes sold the land to the INC. The INC then filed an amendment complaint, dropping Carissa as defendant and changing the nature of the case to a mere action for damages. Soko filed a motion to strike out the amended complaint on the ground that it was filed without leave of court. Should the amended complaint be expunged from the records? No. Where some but not all the defendants have answered, the plaintiff may still amend the complaint as a matter of right as against the non-answering defendant or defendants. Soko versus Court of Appeals. Here, Soko had not filed an answer, hence the INC can still amend the complaint as a matter of right. On September 10, 1981, private respondents filed with the SFI of Pasay an action for specific performance and damages to compel petitioners to execute a deed of sale over a parcel of land in their favor. Civil case number 9412. On 16 September of the same year, the private respondents filed another case for annulment of sale and damages against the petitioners and the Quaisons when the private respondents learned that the land had been transferred by the petitioners to the Quaisons. Civil case number 9432. Civil case number 9432 was eventually dismissed on the ground that the private respondents had split their cause of action. In 1996, after petitioners had already filed their answer, the private respondents filed a motion for leave to admit amended complaint in civil case 9412. The amendment consists of changing the nature of the case from specific performance and damages to annulment of sale and damages. The petitioners opposed the motion on the ground that the amendment substantially changes cause of action and the theory of the case should the amended answer be admitted. Yes, granting arguendo that the amendment would change the cause of action and theory of the case, the clear import of the 1997 Rules of Civil Procedure when it deleted the phrase or that the cause of action or defense is substantially altered is that the amendment may now substantially alter the cause of action or defense. This should, however, be true when the amendments sought to be made shall serve the higher interests of justice, prevent delay, and secure a just, speedy, and inexpensive disposition of every action or proceeding. In the interest of substantial justice, the amendment is allowed so as to afford party litigants the full and genuine opportunity to substantiate their respective claims and defenses and for the court to decide the case on the merits. Valenzuela versus CA 363 SCRA 777. Respondent WGNA entered into a lease contract with the Philippine Ports Authority over a marine slipway in the North Harbor. The lease contract provides that the lease of the area shall take effect on January 1, 2001 to 30, 2001 June, or until such time PPA turns over its operation to the winning bidder in the North Harbor modernization. Believing that the lease contract is expired on June 30, 2001, PPA wrote a letter to respondent asking it to vacate the leased premises. Respondent replied that the lease contract is up to the turnover of the premises to the winning bidder, but the PPA insisted on its stand. Respondent thus filed an action for injunction against PPA. PPA filed its answer, then WGA filed a motion to admit amendment or amended complaint. The amended complaint is for injunction and reformation of the contract. PPA opposed the admission of the amended complaint on the ground that the reformation sought by respondent constituted a substantial amendment, which is, if granted, will substantially alter the respondent's cause of action and theory of the case. Should the trial court admit the amended complaint? Yes. The trial court should admit the amended complaint. Under the 1964 rules, the court may grant leave for a substantial amendment unless the motion was made with intent to delay the action or that the cause of action or defense is substantially altered. The 1997 rules amended the old Section 3, Rule 10 by deleting the phrase or that the cause of action or defenses is substantially altered. The clear import of such amendment in Section 3, Rule 10 is that under the new rules, the amendment may substantially alter the cause of action or defense. Philippine Ports Authority versus William Gotong and Aboitis. GR 158401. Plaintiff filed a case against defendant for annulment of real estate mortgage. The complaint states that the plaintiff was defrauded into signing the mortgage. During the trial, the plaintiff without objection presented evidence that the mortgage property was conjugal property and that his wife did not give her written conformity thereto. No amendment of the complaint was made. May the court render judgment annulling the mortgage on the ground that the spouse's written consent was not obtained? The answer is yes. Under Section 5, Rule 10, when issues not raised by the pleadings are tried with the express or implied consent of the parties, they shall be treated in all respect as if they had been raised in the pleadings. No amendment of such pleadings deemed amended is necessary to cause them to conform to the evidence. Here, the defendant's failure to object amounted to an implied consent to the trial of the issue of lack of spousal consent. Same as above, but the defendant timely objected to the introduction of evidence regarding lack of spousal consent. How should the court rule on the objection? The court should sustain the objection. The second sentence of Section 5, Rule 10, which provides that if evidence is obtained at the trial on the ground that it is not within the issues made by the pleadings, the court may allow the pleadings to be amended and shall do with liberality if the presentation of merits of the action and the ends of substantial justice will be subserved thereby, was deleted in the 2020 Rules of Civil Procedure. Furthermore, under Section 7, Rule 18, the contents of the pretrial order shall control the subsequent proceedings unless modified before trial to prevent manifest injustice. Hence, such modification of the pretrial order cannot be made during trial. A complaint was filed by the Counsel for Superior Sales, an entity without a distinct juridical personality, against Mr. Garcia on a money claim for goods delivered. Mr. Garcia did not file a motion to dismiss. Eventually, trial was held and his liability was established through several invoices, each of which uniformly showed on its face that Mr. Tan is the proprietor of Superior Sales. After Superior Sales had rested its case, Mr. Garcia filed a motion to dismiss on the ground that since there is actually no person properly suing as plaintiff, no relief can be granted by the court. On the other hand, the Counsel for Superior Sales filed a motion to amend the complaint to make it conform to the evidence that the real party plaintiff is Mr. Tan. The court denied the said motion on the ground that it was filed too late and instead dismissed the case. Did the trial court act correctly? No, the trial court did not act correctly. Under the rules of civil procedure, when issues not raised by the pleadings are tried with the express or implied consent of the parties, they shall be treated in all respects as if they had been raised in the pleadings. No amendment of such pleadings deemed amended is necessary to cause them to conform to the evidence. Here, the issue that Mr. Tan was the real party in interest was tried with the implied consent of the parties since Mr. Garcia failed to object to the presentation of the invoices. Hence, there was even no need to amend the complaint to conform to the evidence. Same preliminary facts as in the preceding problem. However, Mr. Garcia filed an answer raising the defense that the plaintiff is not a real party in interest. During the trial, Mr. Garcia objected to the presentation of the invoice, showing that Mr. Tan is the proprietor of Superior Sales on the ground that in the pleadings, the plaintiff is Superior Sales. If you were the judge, how would you rule on the objection? If I were the judge, I would sustain the objection on the ground that it is not within the issues made by the pleading. Under the 2020 Rules of Civil Procedure, the portion of Section 5, Rule 10, which allowed an amendment to authorize presentation of evidence where the evidence was objected to on the ground that it is not within the scope of the pleadings, was deleted. During trial, plaintiff was able to present without objection on the part of the defendant in an ejectment case evidence showing the plaintiff served defendant a written demand to vacate the subject property before the commencement of the suit, a matter not alleged or otherwise set forth in the pleadings on file. Was the jurisdictional defect of the complaint cured? Yes, the jurisdictional defect of the complaint was cured. Section 5, Rule 10 provides that when issues not raised by the pleadings are tried with the express or implied consent of the parties, they shall be treated in all respects as if they had been raised in the pleadings, and no amendment of the pleading is necessary to cause them to conform to the evidence. Here, the issue regarding the written demand to vacate was tried with the implied consent of the parties due to the defendant's failure to object. Hence, the complaint was deemed amended to include all allegations regarding the written demand to vacate. Here, the amendment of the complaint took place by operation of law under Section 5, Rule 10. Thus, the amended complaint superseded the original complaint and jurisdiction was thus acquired by the court. Plaintiff filed an action publicana before the RTC against the defendant. The complaint did not contain any allegation regarding the assessed value of the subject land. The defendant's motion to dismiss on the ground of lack of jurisdiction was denied, and the trial court rendered decision in favor of the plaintiff. On appeal, the plaintiff appellee annexed to his brief the tax declaration of the property showing that it had an assessed value of more than 50,000. No objection was interposed by the defendant appellant. The defendant argued that the trial court did not acquire jurisdiction because of the failure to allege the assessed value of the land. The plaintiff countered that in accordance with Section 5, Rule 10, the lack of jurisdiction was cured by the introduction of the tax declaration without objection by the defendant. Was the lack of jurisdiction cured by the introduction of the tax declaration? The answer is no. The plaintiff's invocation of Section 5, Rule 10 to support his claim that failure of the defendant to object to his presentation of the tax declaration before the CA constitutes an implied amendment is misplaced. Such rule contemplates an amendment to conform to or authorized presentation of evidence before the trial court during the trial on the merits of the case. Here, plaintiff presented the tax declaration to prove the assessed value of the property for the first time on appeal before the CA in his brief. There was no proof or allegation that he presented the same during the trial or that the court examined such document. Since the tax declaration was never duly identified by testimony during the trial, albeit incorporated in the appellee's brief, the CA will not be required to review such document that was not previously scrutinized by the RTC. As the assessed value is a jurisdictional requirement, the belated presentation of document proving such value before the appellate court will not cure the glaring defect in the complaint. Thus, jurisdiction was not acquired. Cabrera versus Clarin. In the trial of a homicide case, the fiscal was able to prove treachery and evident premeditation without objection on the part of the defense. By reason thereof, the fiscal moved to amend the information invoking the provisions of the rules of court, which allows amendment of the pleadings to conform to the evidence. He then filed an amended confirmation changing the homicide that of murder, which, however, was vehemently objected to by the defense. Resolve the merits of the fiscal's motion to amend. The fiscal's motion to amend the information should be denied. The provisions of Section 5, Rule 10 do not apply to criminal cases, which are specifically governed by Section 14, Rule 110, under which a substantial amendment can no longer be made after the accused had pleaded. Here, the amendment is substantial as it seeks to change the nature of the offense charged and the accused had already pleaded, since the case had already reached the trial stage. Hence, the motion should be denied. Plaintiff sued defendant for collection of the purchase price of the land in the amount of $2.2 million. Defendant in her answer stated that she had paid $2 million and therefore owes to the plaintiff only $200,000. During the trial, defendant without objection presented a receipt showing payment of the $2 million or in payment of $200,000, nor did the plaintiff object to the admissibility of the receipt when it was formally offered. The trial court rendered judgment dismissing the case, stating that defendant had fully paid her obligation. On appeal, defendant contends that the trial court erred in considering the evidence of payment since there was a judicial admission by defendant that she still owes $200,000. Is the defendant's contention correct? The answer is no. It is noteworthy that when defendant presented the evidence of payment, plaintiff did not object thereto. When the receipt was formally offered as evidence, plaintiff did not manifest their objection to the admissibility of said document on the ground that payment was not an issue. Since there was an implied consent on the part of plaintiff to try the issue of payment, the RTC cannot be faulted for admitting respondent's testimonial and documentary evidence to prove payment. De la Cruz versus Concepcion. What is a supplemental pleading? It is one setting forth transactions, occurrences, or events like TOE, transaction, occurrences, or events, which have happened since the date of the pleading sought to be supplemented. Upon motion and upon reasonable notice and such terms as are just, the court may permit a party to serve as supplemental pleading. In November 1989, petitioner Super Clean Services Corporation filed with the RTC a complaint for mandamus or certiorari seeking to compel the home development or in mutual fund to award the 1990 janitorial contract to petitioner as the lowest bidder. HDMF filed an answer alleging the petitioner did not qualify as a bidder. In 1991, petitioner moved for the admission of a supplemental complaint, alleging that the delay in the case had rendered it moot and academic, and accordingly, instead of pursuing its prayers for mandamus, it was now seeking damages. The trial court denied the motion to admit the supplemental complaint. Was it proper for petitioner to supplement its complaint? No. The supervening event was cited not to reinforce or aid the original demand, but to change the relief sought to one for a recovery of damages. Hence, petitioner's remedy was not supplemental, but rather to amend its complaint. Indeed, the new relief sought is actually an alternative remedy to which petitioner was entitled at the time of the filing of its original complaint. Super Clean Services Corporation versus Court of Appeals. GR 25 or SCRA 258165. Nonetheless, the trial court should simply have allowed the plaintiff to file a motion to admit amended complaint rather than denying outright the motion to admit supplemental complaint. P filed a complaint for damages against D for breach of contract. In his complaint, P alleged that D completed only 3/4 of the house he undertook to construct. Subsequently, P amended his complaint by alleging that D completed only 1/2 of the house. Trial was held, and thereafter the parties submitted their evidence. The original complaint was not marked and offered in evidence. May the court, in rendering its decision, take into consideration P's statement in the original complaint that D completed 3/4 of the house? No. An amended pleading supersedes the pleading that it amends. Hence, admissions in the superseded pleadings are merely extrajudicial admissions and still need to be offered in evidence if a party decides to use them. King versus Court of Appeals. These should have offered the original complaint in evidence. In an action for reconveyance of a parcel of land filed in the regional trial court, the defendant, through his lawyer, filed an answer therein admitting the averment in the complaint that the land was acquired by the plaintiff through inheritance from his parents, the former owners thereof. Subsequently, the defendant changed his lawyer and, with leave of court, amended the answer. In the amended answer, the above-mentioned admission no longer appears. Instead, the alleged ownership of the land by the plaintiff was denied, coupled with the allegation that the defendant is the owner of the land for the reason that he bought the same from the plaintiff's parents during their lifetime. After trial, the regional trial court rendered the decision upholding the defendant's ownership of the land. On appeal, the plaintiff contended that the defendant is bound by the admission contained in his original answer. Is the contention of the plaintiff correct? No. The contention of plaintiff is not correct. Under Section 8, Rule 10, an amended pleading supersedes the pleading that it amends. Hence, the admission in the superseded pleading cease to be judicial admissions and may not be considered by the court unless offered in evidence. So that ends our Rule 9 and 10 and some part of Rule 8. Again, thank you so much for your support. And if you're not yet subscribed to our channel, go ahead and hit that subscribe button and let's study together. As well, please forgive the lapses in pronunciation as I'm reading nonstop so we can cover more. And if you have any other comments, please hit the comment box and I'll read them.